All rise. All persons having business before the Honorable Associate Judges, now residing over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Thank you. Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have two cases on this morning's regular calendar. The first one is 22 CV 274 and 22 CV 301, Felicia, not sure, SONMEZ versus Washington Post Company, LLC. Whenever you're ready, counsel.
May it please the court, Madeline Meth for appellant Felicia SONMEZ. If I may, I'd like to reserve 3 minutes for rebuttal.
Sure, and I should just say at the outset that normally when we have cross appeals, we still try to do it in the 1, 2, 3, so you can cover all issues when you get up. Does that make sense? Okay, thank you.
Defendants discriminated against Felicia SONMEZ, a Washington Post breaking news reporter, because of her sex and because of her status as a victim of a sexual offense. I'll begin with how the complaint adequately alleges victim status discrimination. The complaint alleges that SONMEZ's supervisors told her that they were limiting her assignment because the circumstances of her sexual assault were too similar to the accusations levied against Justice Kavanaugh. Later that same day, one of SONMEZ's supervisors probed her at work about the sexual assault that she had experienced in China, asking her why she didn't go to the Beijing police and telling her that a woman should just say no if a man tries to assault her. Newspapers are, of course, free to neutrally enforce policies about objective reporting. However, from these statements, which a jury could conclude have nothing to do with that proffered legitimate reason for barring SONMEZ from covering Me Too, a jury could determine that defendants violated the DCHRA by engaging in victim status discrimination. For nearly 2 years, SONMEZ was barred from covering anything even tangentially related to sexism. The ban hung over her everyday experience, and because its reach was not clear or predictable, for each story SONMEZ was assigned, she had to steel herself for the moment a Me Too connection might emerge, and she might have to explain to her colleagues why she was stepping away. And these allegations only scratch the surface on the facts that demonstrate DCHRA prohibited victim status discrimination. Turning to the comparator allegations, the complaint alleges that one Asian American reporter who frequently spoke out about anti-Asian hate crimes and publicly objected to the media's coverage of such crimes was allowed to continue to write stories on anti-Asian violence, publicly defended from online harassment by editors, and permitted to appear on CNN to discuss the issue. And I point the court to JA 42 through 43, where these comparator allegations are addressed. Defendants also have no answer to the allegations that demonstrate at this stage that their purportedly legitimate motive for narrowing SONMEZ's job assignment was pretextual. That the Post lifted the coverage ban only after Politico published a story detailing defendants' mistreatment of SONMEZ and their purported rationale for that mistreatment is perhaps the best evidence that defendants were never really concerned with a public perception of bias. And this is at JA 46.
So we at the outset need to determine what standard applies, whether it's a regular 12v6 or whether we're in SLAPP territory. And a lot of the allegations that you have pointed to are about assignments that she works on, how they want her to engage in social media. These all seem to be kind of wrapped up in how the Washington Post wants to engage in its expressive or First Amendment protected conduct. So are you kind of conceding that we might be in SLAPP land, or what is your argument for why we're not?
No, Your Honor. So as the ACLU of DC, which helped draft the Anti-SLAPP Act, explains in its amicus brief, defendants have not shown, based on SONMEZ's allegations, that restricting her assignment was expressive conduct that involves communicating views to members of the public in connection with an issue of public interest. And so SONMEZ's challenge to the coverage ban is not a strategic lawsuit against public participation subject to the Anti-SLAPP Act. And I'd also note that although we've been talking about the coverage ban, there are also allegations in the complaint that have to do with a negative performance review, with impacts on pay, a suspension, a denial of security. And the defendants have never argued that those actions were expressive conduct subject to the Anti-SLAPP Act. But focusing on the coverage ban and why defendants have not met their burden to demonstrate that the Anti-SLAPP Act covers here, I'd point the court to how the allegations demonstrate that the behind-the-scenes ban did not communicate anything with the public. Indeed, it was confidential. And this is at JA 24 that describes the ways that defendants sought to keep the ban confidential. To the extent that the ban communicated anything with the public at all, consider the various messages that readers might have received from SONMEZ's byline being missing from some stories. that she was on vacation.
Is that how we look at it, though? I mean, isn't it about they get to choose who's putting out the stories and the messages, not that they need to tell the public why they're making particular assignments?
For it to be covered by the Anti-SLAPP Act, the conduct must communicate a view with members of the public. And again, I'd point the court to the ACLU's brief at
But
page
how,
11.
isn't it communicating a view if I want the Republican to write the editorial versus the Democrat? I mean, that's because I want a particular viewpoint to be put out in the world, and I don't need to say that's why I'm doing it, correct?
That may be, Your Honor, but in this case, I'd ask that the court consider all the various messages that might have been received by SONMEZ's byline being left off of a particular story. So that she was on vacation, that she was assigned to cover something else, that she was being discriminated against, that she was on book leave. And so here, the defendants have not met their burden of demonstrating that the particularized message that they say they intended to communicate was in fact being communicated. And it's unlike the hypothetical that you've offered where an editorial is being written by a Republican or a Democrat and a message may be received. Here, the allegations are that the ban was confidential, again, JA 24. And the moment that the ban became public, when the Politico story was published, that's the moment when defendants lifted the ban. And so defendants have not met their burden of demonstrating that the ban communicated a message.
I mean, part of the ACLU's point is that the Anti-SLAPP Act might not protect all activity that's protected by the First Amendment. And one thing that the Washington Post argues is, okay, so even if you set aside the Anti-SLAPP Act, surely newspapers electing which writers they want to communicate their messages is protected First Amendment activity. And what's your response to that?
So defendants have not met their burden to prove that the First Amendment protects their decision to prohibit SONMEZ from reporting on Me Too on a discriminatory basis. And this is not the appropriate time for them to be litigating what is an affirmative defense, which is not obvious from the face of the complaint. And it's not even obvious.
I don't understand. I just want to interrupt you because I don't understand the answer. So if their response to your complaint, and this was one of their responses, is this suit is non-viable because it speaks and it attacks a First Amendment decision that we as a newspaper have made about who we want to deliver our messages. Dismiss the suit for that reason. The trial court doesn't exactly dismiss the suit for that reason, but does say more or less, well, this is in fact obviously a First Amendment protected activity, suggesting that that's where this is going if in fact the trial court got to the First Amendment issue. Your answer to me had something to do with burdens and this isn't the right time. I don't understand that answer.
So that's because this is an affirmative defense. So it would be defendant's burden to prove using evidence to a jury that the First Amendment defense applies, unless the defense was obvious from the face of the complaint, which it's not. And here's why. Conduct that's protected by the First Amendment is conduct, and I'm paraphrasing this court in Potts, that involves an intent to communicate a particularized message where the likelihood is great that the message would be understood by those who viewed it. And for the reasons that we've talked about, no particularized message was communicated by this confidential ban, according to the allegations in the complaint. There's certainly no allegations that demonstrate a great likelihood that that message would have been received by the public. And I also want to emphasize that it's not even clear from defendants' arguments on the First Amendment what standard defendants think would apply if the First Amendment governed here. And by that, I mean, it's not clear whether defendants advocate for intermediate scrutiny, for example, or something else. And so one of the things that comes out of considering what standard would even apply here is imagine that it is First Amendment protected conduct for the Post to decide to leave SONMEZ's byline off of certain stories. Well, why did they have to prohibit her from covering the stories at all? Would limiting her byline have been enough? And I'd point the court to, for example, Passaic Daily News, which defendants cite, but which actually supports SONMEZ on this point. In that case, the DC Circuit affirmed an NLRB order that the news organization had violated labor laws, anti-discrimination provisions by reassigning a reporter that engaged in NLRA protected activity, and held only that language compelling the news organization to print the reporter's weekly column without providing specific language, preserving the newspaper's editorial control. Only that tested the First Amendment. And on remand, the board was instructed to, the news organization was instructed to restore the reporter to the column writing duties he enjoyed and to decide whether to publish his submissions based upon factors other than the discrimination.
Can I take you in a slightly different direction, if that's okay? I'm also a little confused as to what is the allegations based on her victim status versus her gender, and if they're sort of wholly encompassed in each other. I mean, it strikes me you could have a victim who is not of her gender, and so I guess help me tease that out.
Sure, Your Honor. So the victim status discrimination allegations we talked about at the jump. And as to the sex discrimination, I want to touch on one of the several reasons why the complaint also sufficiently alleges sex discrimination. So SONMEZ wasn't just barred from covering stories with sexual assault allegations similar to the circumstances of her own assault. She was barred from covering anything tangentially related to sexism. And defendants argue that the nature of the stories, that is that the stories she was barred from covering related to Me Too, which we all know is a movement focused on power dynamics between men and women, not just focused on sexual assault, no matter the gender of the victim. They say that this is irrelevant to the reasons for assigning them. But I think a jury could conclude otherwise. And I think an example helps illustrate this point. So if a store reassigns a female employee out of sporting goods and into makeup or lingerie because it thinks that it's mostly male clientele for sporting goods won't want to buy sporting goods from the female employee, that the nature of the assignment, sporting goods, is related to the male clientele, is relevant to the question of discriminatory intent. And the same is true here, where the ban, the breadth of the ban was all of Me Too, this movement about power dynamics between men and women. And so from that, a jury could conclude that the defendants would not have treated a male victim of sexual offense the same way that it treated here SONMEZ, a female victim of sexual offense. So on the question of whether the discrimination was with respect to terms, conditions, or privileges of SONMEZ's employment, I'd note that a case that presents this question about the meaning of the phrase terms, conditions, or privileges of employment is pending before the Supreme Court. That case is Muldrow versus City of St. Louis. It presents the same question as the DC Circuit recently ruled on in Chambers about the meaning of this phrase. And
The trial court didn't sort of pass on the adverse action piece, and so I think we can put that to the one side. I guess, is it possible, do we have to decide what is a gender-based discrimination claim here versus an offense or victim-based discrimination claim? And if we don't have to decide at the 12B6 stage, does it have to be decided at some point, or can you kind of proceed to a jury with it's A or B, but I don't have to tell you which?
That's right, Your Honor. A jury could weigh the evidence and decide whether this was solely about victim status, whether it was about her gender and victim status together, whether it was about sex.
Can I ask you a line drawing question about that? The sex offense survivor status. The claim is that she was discriminated against because she was speaking out or responding to harassment, related to it. How do we know that that falls within survivor status? Sex offense survivor status, and how do you draw the line? So how far does it extend?
So the court doesn't need to draw that line here, because the allegations that I mentioned when SONMEZ was first told she was being barred from covering certain stories, this is at JA 21 and 22, have nothing to do with public statements. They are solely about the circumstances of your assault are too similar to the circumstances of another victim of a sexual offense, and then later the same day being probed at work about this sexual assault. And so for that reason, the court could, based solely on those allegations that have nothing to do with public statements, that have nothing to do with this proffered reason about objectivity, reverse the district court or the Superior Court's conclusion.
Remind me of the chronology of those statements, and at what point in the timeline they took place. If I'm not mistaken, they took place shortly after public statements that Ms. SONMEZ had made. I believe expressing solidarity with another victim of Cayman's abuse. So, I mean, taking the vacuum, if you say, oh, your situation is too similar, if you take that in a vacuum, I would agree with you. But if it's your situation is both too similar and has now been broadly has been broadcast, and you're kind of at the middle of this public firestorm, that seems very different. So chronologically speaking, am I misstating the timeline?
No, you have the chronology right, but I would point the court to JA 21 and 22, where the allegations do not suggest that the defendants were precisely connecting the similarity and the public statements.
I mean, doesn't the timeline kind of necessarily mean that, though? I mean, if we're talking about a long period of time, I don't remember exactly how long, after the Washington Post had hired Ms. SONMEZ and allowed her to report on instances related to the Me Too movement, related to sexual abuse. Then on day 278, she is in the midst of what is a bit of a public firestorm about the LA Times investigation. She makes some public statements about it. And then the next day, day 279, editor says, we're going to put you on the sidelines for a couple months because this is all too similar. I mean, you would think you could use the previous 278 days in the public statements as context for those statements, right?
I think a jury certainly could use that as context, although I do want to clarify one point of context, which is that when SONMEZ was reporting without any issue on issues of sexual misconduct, including on the allegations against Justice Kavanaugh, first, not a single complaint was lodged inside or outside the Post regarding her reporting. And this is at JA 21, but not just was there no single complaint lodged, it was after she had made public statements about this and the Post was aware of this. So this is at JA 16 and 17. But certainly a jury could consider the timeline that you're looking at, Judge Deal, and the jury would have to weigh the evidence and make a determination as to what was the real reason here. And again, I point the court to the comparator allegations and the allegations that demonstrate that the Post's reason was pretextual.
Do you think religious status is a good comparator?
That religious status would be a good comparator? I think so. By comparator, I'm sorry, do you mean that
that it's analogous to the survivor victim status?
So yes, in the sense that they're both protected characteristics under the DCHRA.
Okay, but other than that, not peculiarly.
I'm not sure that I think it's particularly analogous.
I wanted to ask you about retaliation. It strikes me that the complaint just repeats all of the same allegations for discrimination for retaliation and then also for hostile work environment. And so, in a normal situation, you are discriminated against, you speak out about that, you then get retaliated for it. So where is that separation here? Or are you arguing that kind of everything after the first allegation of discrimination is also retaliation?
I think a jury could draw the conclusion that everything after the opposition to what SONMEZ reasonably believed was discrimination after the first ban, a jury could draw the conclusion that that was retaliation. It's similar to what we were talking about earlier, that it would be up to the jury to decide, is this purely sex discrimination? Is it purely victim status discrimination? Is it some combination? And here, the same would be true as to, is it retaliation because we have the allegations that demonstrate protected oppositional activity? And this is at JA 23 and 32. And I know you mentioned the hostile work environment as well. So I want to just home in on why defendants are wrong about the relationship between this claim and SONMEZ's discrete sex and victim status based discrimination claims. So of course, for the reasons that we've already talked about, we believe SONMEZ has plausibly alleged DCHRA prohibited discrimination. But even if she hadn't, the allegations here would still make out a hostile work environment claim because they demonstrate that sex and victim status were impermissibly and pervasively injected into her workplace such that they impeded her ability to do her job. So a quick example helps illustrate the distinction I'm trying to draw. So imagine that a woman who works in a fire station, her male colleagues have put up sexualized photos of women in bikinis on the walls. And the allegations in the complaint are that they do not intend to discriminate against her based on sex, but these posters are operating to humiliate her and make it impossible for her to do her job. And
Cases like that, I mean, it's pervasive. The posters are up day in and day out. I mean, here we have a few isolated instances, right? Unless you're saying that the second ban was one long hostile work environment.
so my point is that the ban was injecting sex and victim status into SONMEZ's workplace because she had to disclose sometimes more than twice a week that she was a victim of sexual assault in the workplace. And this is at JA 29, 32, and 46. And it hung over her workplace. And so it operated the same way that posters in a workplace might operate. And if there are no further questions, I'll reserve the remainder of my time.
Thank you very much. We will give you some more time as well.
May it please the court, Yaakov Roth for the Post and the editor defendants. I'd like to start, if I could, with the anti-SLAPP issue, because I do think in this sort of unique posture, it presents a threshold question that actually avoids getting into the merits of the claims. And that's because, as Judge Epstein recognized, everything rises or falls with the first step of the anti-SLAPP inquiry, the prima facie case, because Ms. SONMEZ decided not to introduce any evidence at the second stage. And so if we've met our prima facie burden to show that the claims arise from activity within the scope of the statute, then the claims have to be dismissed.
So do we have to dismiss all of the claims, or do we have to parse out what we think relates to sort of expressive conduct from a poor evaluation or lower compensation?
Yeah, I mean, we think that the analysis is claim by claim, which this court has the statute defines to be cause of action, and this court has treated that interchangeably with account. That's in the Bronner case. And so it's true that the bans here are the protected activity, not the other alleged adverse actions, but the bans are form part of every count in the complaint. She made that decision to plead it that way. And so I think that brings with it the heightened anti-SLAPP statute for every count.
For every allegation within the count, even ones that are not related to the.
Yeah, this court hasn't parsed out within a count before. And so we don't think that's the right way to do it. Certainly it covers the claims to the extent they rest on the bans, though. And that's because if you look at the statute and the scope of what the protected activity is, it covers expressive conduct that involves communicating views to members of the public in connection with an issue of public interest. Well, the bans are expressive conduct because they are a form of editorial control and editorial judgment. And the courts have said for a long time in the First Amendment context, editorial judgment is expressive conduct. It's part and parcel of the speech itself. That's the Tornillo case. The Net Choice case in particular walks through this in a lot of detail, and I would recommend that to the court, the 11th Circuit decision.
I'm sorry to keep interrupting you, but you're talking about
Sure.
bans, but only the second ban is actually before
That's
us,
right.
correct? Okay.
That's right. So the ban reflects an exercise of editorial judgment and editorial control that is expressive conduct. And that expressive conduct involves communicating with the public because it controls and dictates the Post's reporting to the public on issues of public interest. Here, the Me Too movement, which this court said in Fells is an issue of public interest.
I mean, it strikes me as a little bit of a stretch to say it's expressive conduct where it is purposely kept under wraps by the Washington Post. I mean, if it would be one thing if the Washington Post said, you know, our policy is we do not allow reporters who are enmeshed in a public controversy to report on anything relating to it. In this particular case, Ms. SONMEZ is enmeshed in this public issue, and so we're not going to allow her to report on it. That would certainly be pure expression. Expressive conduct, I don't know, maybe they post a list on their window every day of reporters that are not allowed to cover certain topics. But what's the expressive conduct here? It's when they purposely are not expressing anything about this ban?
Right. Well, Your Honor, expression is both the freedom to speak and the freedom not to speak, and freedom to decide what to speak about and how to speak about it. And that all is part of the editorial judgment and editorial control that relates to the newspaper's
I
content.
might agree with you if we're talking about a pure First Amendment analysis, but I just want to stick to the statutory language for a second. What's the expressive conduct?
The expressive
the expressive conduct is
the decision not to allow Ms. SONMEZ to cover these stories.
so if I get up in the morning and I say, you know what, today I'm not going to say anything about what's going on in the Gaza Strip. I have made what I take to be a choice protected by the First Amendment. Nobody can make me speak to that. Have I expressed? Have I
Your Honor,
undertaken some expressive conduct? Have I communicated views on a matter of public interest?
So, Your Honor, if you are a newspaper and you make that judgment and somebody sues you for it and says you committed a tort by not reporting on the war crimes that are going on, yes, I think that would fall within the scope of the statute because you have made it. That's an expressive determination that I am going to report on other things. I'm not going to report on this. And that is all part and parcel of what a newspaper does when it decides how to present to the public, world affairs and public affairs.
I suppose I'm surprised you're taking the position that it's the decision not to allow Ms. SONMEZ to speak about things as opposed to the decision to have those less connected with the controversy report on it.
I think it's two sides of the same coin, Your Honor. There was reporting going on. There was publication going on. There was coverage. It was happening through other reporters. And that decision, right, who to assign to cover these stories is part of the expression itself and therefore is expressive conduct within the scope of the statute.
What about Judge Epstein says, I think, if I'm remembering this right, that his ruling on the inapplicability of the anti-SLAPP law is supported by the California case that everyone's talking about because that case relies on the part of the statute in California that is not what we have here. Is that correct?
The statutes are different in text, and the court should obviously look to the DC statute and not the California statute. But I have put them next to each other and tried to identify exactly what the meaningful difference is in this respect. And it's a little bit hard.
But do you
to see
agree
what it
with
is.
Judge Epstein's analysis of the California case? And
Well,
how-
the California case is Wilson is the key
Yeah.
case from the California Supreme Court. And Justice Kruger wrote, I think, a really well done opinion that explains why personnel decisions, if they are, at least on a prima facie basis, motivated by editorial considerations, fall within the scope of California's anti-SLAPP statute. She did that obviously using the text of California's statute, and she focused on conduct and in furtherance of. We also have in furtherance of, it's the defined term here, but the court can look at the defined term in construing what the definition means. And she focused on conduct. We have expressive conduct, but I don't think that's a material distinction for our purposes because under cases like Net Choice and Tornillo, the decision about the coverage and who's going to cover a story and what's going to be covered is expressive conduct when you're a media entity like a newspaper.
And what do you think about the concept extending beyond a media company?
Well, I mean, every case is different. I don't know.
Well, let's please.
Go ahead.
You run a Starbucks, but your belief is that really only white people should be serving coffee, believing them to be, other races to be inferior. And so what I want to do when I run my Starbucks is only white people are going to serve coffee. And I'm expressing something, which is that that is the only race that is worthy enough to serve customers coffee. Is that protected under the Anti-SLAPP Act?
I don't think so for a few reasons. Number one, I think it would probably fall under the commercial exception because you're in the context of a commercial entity making a commercial decision about how to sell a product rather than expression. And you don't have the same background that we have in the media context of these cases holding your determinations about the content of the newspaper are for expressive.
But if we move it to a newspaper, let's somebody wants to run white power newspaper and they only want to hire white journalists, you would say that is protected by the Anti-SLAPP Act.
Let me try to flip that. Imagine that you have.
I'm just wondering what the answer is.
No,
before you can flip it.
I want to answer it, but I want to answer it by just tweaking it, which is imagine you have a newspaper that is doing a symposium on the effect of Black Lives Matter movement and chooses to assign those stories to Black reporters rather than white reporters. Yes, I think that would probably fall within the scope of the anti-SLAPP statute if somebody sued over that decision.
So would that also extend to like a school that didn't want to hire women because its view is that women shouldn't be working outside of the home, and that's their view?
Well, I don't know that a school is engaging in communication with the public in the same way that a newspaper is. So I think there's a distinction there, right? When you're a newspaper, you're reporting every day to the
Yeah,
public
although
about issues of public concern.
You can imagine a school that really has a reputation and wants to uphold it and wants everyone in this town to know this is the kind of, not woke school that they can rely on or something. Like, why is that different?
I mean, if they made a public statement about it, then that might change the analysis, I think. But if you don't have that sort of context of communicating views to members of the public, then I don't think I don't think it's an easy extension to that scenario. We're in really a core case in my view here, because
So,
we are really talking about
we may be in a core case. I'm just
Yeah.
trying to figure out what your limiting principle is.
Yeah.
So you're saying that having only Black reporters cover BLM is within that. So any media company is now sort of subject to the anti-SLAPP heightened standard anytime they want to use race or gender, even if it's disconnected from their expressive purpose?
No, I want to be very clear. And I would point the court to Justice Kruger's analysis of this, because she says, look, it's not every personnel action that you take just because there's some downstream incidental impact on speech. That takes it too far. However, if the decision itself is a decision about the content, as it is here, and the reason for the decision, again, at least as a prima facie case matter, is considerations of editorial standards and journalistic standards and so on, then you are within the scope of the statute. That's a pretty narrow set of cases. They do exist. Wilson is an example of one, and there are a few others in California. This is not like this happens all the time. The Post has never invoked the anti-SLAPP statute in an employment case before. This is a very unusual discrimination.
So what if I am the Washington Post and didn't want to hire individuals that observe the Sabbath because breaking news reporters need to be available, 24/7. Is that under?
I don't think that would trigger the anti-SLAPP statute. That's not an expressive determination. It has nothing to do with editorial standards. If anything, it has to do with commercial considerations. So I don't think that would.
But it's not an editorial judgment to only have breaking news reporters that can be available?
No, I don't think that's an editorial judgment. It doesn't go to the content of the paper in the way that the claims here directly challenge the content of the newspaper. So, look, we think for that reason, the court doesn't have to go any further. It can dispose of the appeal based on the first step of the anti-SLAPP statute, and doesn't need to reach the merits. But I'd like to transition to the 12b6 analysis, because we also believe Judge Epstein got it right when he determined that the claims had not been plausibly alleged. So just starting with discrimination, and I think the critical point that Judge Epstein picked up on is every adverse action that is alleged in the complaint, or I should say every alleged adverse action that is identified in the complaint, is tied both logically and chronologically to Ms. SONMEZ's speech that's adjacent to it. So you have the first ban imposed literally the day or within a day of the press release that took positions on the Me Too movement. Then that lapses and they tell her, if you choose to speak out again publicly, it could have implications for what you're able to cover. Then there's nothing happens for 9 months. Then she chooses to engage again publicly in these Twitter feuds about Me Too issues, and they promptly reimpose the restriction on her coverage. Then you have the tweet about Kobe Bryant, which immediately triggers a suspension, right? Every action in the complaint is clearly tied to her public advocacy, and public advocacy is not protected under the DCHRA.
So I think part of their argument is, look, others were allowed to engage in public advocacy. You have Ms. Lee, who's engaged in some public advocacy about anti-Asian hate crimes. And, I assume their sports reporters are allowed to say, go Commanders and stuff like that during their spare time. So this seems to be a burden that falls uniquely on the post's concerns about objectivity seem to fall uniquely on victims of sexual abuse in the way that they don't fall on other reporters. Wouldn't that be a viable basis to allege discrimination on? You're especially muzzled if this is your.
I think it would if it was plausibly alleged. I don't think it's plausibly alleged because that it's really only that the Michelle Lee comparator allegation, I think, tries to do that. I think the obvious difference is condemning anti-Asian hate crimes, which is what Ms. Lee is alleged to have done, is not a hot button social or political debate. It just isn't, right? That is not the type of statement that's going to give rise to concerns about appearances of conflict.
I mean, that seems hard to say in a sort of post-COVID world in which there is considerable, controversy over these issues. I mean, who's to determine kind of what discrimination is hot button versus not?
Well, I think the court has to look at the allegations with some degree of sort of common sense. This is, by the way, pre-COVID allegations. It's not a secret. The Me Too movement has become a very hot button social debate where people have very strong views. And Ms. SONMEZ was weighing in on those issues. She was not saying, sexual violence is bad, which would not have caused any of this. We wouldn't be standing here today if she had tweeted end sexual violence, right? Her statement took positions on issues like, should an employer's investigation of allegations be transparent or private? Should somebody—
It's very personal.
It was very personal, and it was clearly something she was personally felt very strongly about and felt very invested in. But that's exactly why the Post made the determination that it would be better for other reporters to cover these stories. And that's not a violation of the statute because it relates to the way she was taking positions on these issues in the public eye and not based on her victim status. Now, Judge Beckwith, you asked about religious discrimination as a potential analogy, and I think it's a good analogy. If I was a reporter and my employer said to me, you're Jewish, we don't want you to cover the war in the Middle East, that would be discrimination based on religion. It might be protected by the First Amendment, but it would be religious discrimination. If I went on Twitter and made a bunch of comments about the war, and the employer said, we're taking you off the Middle East beat as a result, that would not be religious discrimination. That would be discrimination based on my public statements on the issue. Another example, the statute protects political affiliation. The DCHRA does. So a newspaper couldn't say, you're a registered Republican, we don't want you to report on the election. Okay, again, maybe that's protected by the First Amendment, but under the statute, at least, that would be discrimination. But if somebody goes and makes a bunch of comments about, Trump should win the election, and the newspaper says you're not going to cover this anymore, I don't think you have a plausible allegation there of discrimination based on political affiliation.
Limited that strictly to identity alone? Aren't there, things that go along with being, in one of those categories or being a survivor? And are covered, and where do you draw the line?
Right. So, well, I think what's really helpful on that, Your Honor, is the council specifically actually went further. So you have the prohibition that first they add victim status to the statute, and then they add several other provisions that protect additional activity that is related to victim status. So you can't take action based on someone seeking mental health treatment. You can't take action based on participation in a judicial proceeding related to sexual assault. You can't take action because somebody the abuser disrupted the workplace. They had to add all of those things because they are additional conduct that goes above and beyond the victim status. But they did not protect, and they did not say speaking out publicly about sexual assault is a protected act. So I think this council's really drawn the line for us, and in a way that leaves Ms. SONMEZ out.
Can you just, there is a dispute in the briefs about the degree to which Ms. SONMEZ actually engaged in anything that could be fairly described as advocacy. We don't have really a record before us. We have some allegations. Paragraph 35 of the complaint provides what you might describe as a pretty tepid statement. I know you highlight the word solidarity, but that's not with regard to all accusers in the Me Too movement. It's with regard to one particular accuser who shared the same alleged assailant as Ms. SONMEZ, which is not such incendiary stuff. There is some, discussion, I think at page 63, paragraph 63 and 60 through 65 of the complaint about a kerfuffle with Ms. Flanagan.
Right.
We really don't have the specifics of that in the record before us either. I have a hard time sort of evaluating with what I have, the degree to which Ms. SONMEZ engaged in what might be called public advocacy in support of women who allege sexual abuse, sort of in the vein of the Me Too movement. What's your smoking gun on that? Or what's your best evidence that she was sort of fairly described as a public advocate in the movement?
So here's what I would say about that. The first thing I would say is that might matter if the question before the court was, did the Post make the right call on the editorial question of whether she should be taken off these stories? Was there really an appearance of objectivity, or did they overreact, right? Those may be debatable questions, and they may be questions on which we would need more evidence. Those are not the questions presented by the case. Question presented by the case is, did the Post act based on the statements or based on her victim status or sex? And I think we know the answer is it's based on the statements, because the timeline doesn't allow for any other reasonable conclusion when she's allowed to cover these stories until the moment she speaks. Then she's again allowed to cover the stories for months and months on end until she speaks. So look, maybe the Post made the wrong call on taking her off the stories. We don't have to bear that burden here in order to show that she hasn't stated a plausible discrimination.
That might be right, but I would still like to hear your best answer to my question, because, it certainly goes to whether or not this is a plausible, whether or not something's pretextual.
Right.
One relevant factor is, well, what reason did they give?
Right.
And is there anything backing that up?
Right. Okay. So if we look at the first statement, I think the best material in the first statement is not only the expression of solidarity with a particular victim in a context where she has no personal knowledge of that incident, right? She has personal knowledge of her own interaction, not someone else's, and yet she is expressing solidarity with one side in that disagreement about what occurred. Then she says she criticizes the lack of transparency on the part of the LA Times in conducting the investigation and in potentially allowing Mr. Kamen to resign rather than face disciplinary action, right? So that I take to be an expression of opinion about how these sorts of allegations should be handled by employers, and particularly by media employers. That's the first statement. When you get to the second, there's less in the complaint about exactly what was going on. What we know is that there were reporters who were covering the allegations and what happened between her and Mr. Kamen, and she was debating with them about the allegations and about what occurred. That is a sort of different type of advocacy, but it is certainly putting herself very forcefully in the public eye with respect to a debate over a Me Too allegation. And I think that itself is reasonably enough. Again, I don't have to say it's the right decision, but I think it's certainly reasonable enough to say if somebody is publicly engaging in a high-profile Twitter debate about who's right in a Me Too allegation, maybe they're not the best person to cover other allegations of a similar nature. And that's not discriminatory, whether it's right or not, it's not discriminatory.
Can I go back to it, just make sure I understand when I asked you about the line and whether you have to stick to identity, and you mentioned that the statute also has added these provisions about disruption and mental health treatment. And so is it your position that only it's like identity, or something that falls really cleanly within the scope of these other things? And
yes.
So there's just nothing, how do you, is it a legal question, I guess, how narrowly you're going to define what survivor status is?
Well, I'm not sure it's defining what survivor status is. It's limiting the statute to that status. So I think the statute is protecting a status. It is not protecting conduct. And so, other than with respect to the conduct, types of conduct that are expressly enumerated in the later subsections of the act. But that's, I think, the line that the statute is drawing. Is it status or is it conduct? And Judge Epstein concluded from reading the complaint, it's clearly about her conduct. This is not about her status. If it was about her status, it would have been true for the entire period of time, and it wasn't. If I could say a quick word about retaliation. The only actual protected activity that's clearly alleged in the complaint is May 2020, when Ms. SONMEZ sends an email saying this is discriminatory. That's clearly protected activity under the statute. The problem is there's no adverse action that's alleged to be taken after that date. So then we go back to the first ban where she says, this is not fair. I feel like I'm being targeted for what happened to me in Beijing. But that is time barred. She concedes it's more than a year before the relevant period of time. It's also before victim status discrimination is actually illegal. So that leaves us
But
with,
at that point, we're still in retaliation land. So if she was complaining about the first ban, which she can't challenge as discriminatory, but she thinks she was retaliated for having that, wouldn't it be both within the statute of limitations and not related to victim status?
well, it depends when the alleged adverse action is taken. So my point is that complaint was so far before starting when the statute of limitations period, the relevant period of time begins. I don't think you can have any actionable retaliation claim based on something that's quite that early. And
You're saying that would just be lacking in temporal proximity.
It's lacking in proximity. Yeah, it was also a problem of it. It's not an allegation. It's not an allegation of a complaint about illegal discrimination because it wasn't illegal at the time. Even if it was true that they had discriminated based on victim status, that was okay in 2018.
But you don't have to have a viable discrimination claim to have a retaliation.
You have to have a reasonable basis. I don't know I'm not sure what the reasonable basis would be. Regardless, I think the statute of limitations is probably the easier way to deal with that. And so what we're left with is September 2019, when she says she objected to the second ban, quote, for essentially the same reasons. Judge Epstein said that's not clear enough to qualify as protected activity. We don't know what those reasons are. It's a very vague allegation. Of course, there were about 10 reasons she gave when she complained about the first ban. It's sort of telling that she doesn't say that she brought up victim status or sex with respect to September 2019. And even if that was protected activity, nothing happens after that until January 2020, about 5 months later, when she has the Kobe Bryant tweet. And the suspension is just clearly based on the firestorm that erupts from the Kobe Bryant tweet. I mean, tying it back to a complaint from 5 months earlier that allegedly just repeated what she had said a year before that, I think is just not a plausible story of retaliation. I'm happy if there are questions with the First Amendment, I'm happy to address those as well, but otherwise I know I've gone over my time. Thank you, Your Honor.
Thank you very much. Ms. Met, we will give you 4 minutes.
Yeah.
See how that goes.
It does matter whether SONMEZ engaged in advocacy according to the complaint or whether she simply made public statements about her personal experience. And it matters for the comparator analysis. And that's because the comparator allegations show that even if defendants would not have barred SONMEZ from covering Me Too, absent public statements about her personal experience with being a victim of a sexual offense, what was important was that she was a victim of a sexual offense and she made public statements about that protected status. And we know this because, again, Ms. Lee engaged in the same conduct, but was not a member of her protected class. So she frequently spoke out about anti-Asian hate crimes and publicly objected to the media's coverage of those crimes, but was allowed to continue to write stories about that topic.
I think Judge Epstein said she's not a good comparator because she never injected sort of a personal story into it. She didn't claim to be sort of taking up the mantle for a cause that had personally affected her. Is that do I have his reasoning right? And what's your reaction to it?
I think you have his reasoning right, Your Honor. My reaction to it is that it's not a correct reading of the complaint at this stage. The complaint alleges that she's an Asian American reporter who's speaking out about anti-Asian hate crimes, going on TV about anti-Asian hate crimes, and writing stories about these crimes, and that it's not plausible to think that she hadn't had some experience with anti-Asian hate.
But
And so
she's
in that
not
sense,
centering herself, which I think was Judge Epstein's point. So, one can be Asian and write about Asian hate crime. One can be a survivor and write about survivors. But I think the distinction that Epstein found relevant was that Ms. SONMEZ was tying it to her own personal experiences in a way that could question objectivity, correct?
I don't see how that is a relevant distinction for the comparator analysis, because again, the question is whether SONMEZ engaged in public advocacy on the issue that she was reporting on. And if you look at JA 20, I think it's clear that a jury could conclude that she never engaged in any kind of advocacy, and she never took a side on the Me Too movement. She never made claims about the Me Too movement. She did not express solidarity with accusers generally, only with the person who had also been assaulted by her assailant. And she did not condemn the LA Times. She engaged in the same sort of conduct as her colleague who called on media organizations to handle reporting on anti-Asian hate crimes.
What other interpretation other than advocacy is there of the Kobe Bryant tweet? Shortly after his death, posting an article sort of detailing allegations of sexual assault against him.
That she was tweeting a valid news report after his death about allegations of sexual assault and contextualizing his death. I don't think that a jury would have to conclude that she was engaging in advocacy or taking a side on the Me Too movement.
You don't think the clear message from that is nobody forget what this man did, even though he's dead?
I don't think so, Your Honor. And I point the court to, for example, JA 37, where someone receives a different message. A Twitter user writes, how could they suspend her only for sharing a valid news report? Are they sure they're a publication? And so from that, I think a jury could draw the inference that she's a breaking news reporter and she's sharing a valid news report. On the anti-SLAPP questions, I just want to point out that Tornillo and Net Choice, on which my colleague on the other side was relying, they are about content moderation. They are about compelling a speaker to speak. And here, that's not what's going on when the ban is at issue, because the content of the stories would have been the same whether SONMEZ had been allowed to cover Me Too or not. And we know that from the allegations because, again, there was never any complaint lodged inside or outside the Post about SONMEZ's ability to report on these issues without bias. And she had reported on these issues without any problems. And if there are no further questions, we'd ask the court to reverse the judgment of the Superior Court as to the 12B6 motion to dismiss and affirm the dismissal of the anti-SLAPP motion. Thank you so much.
Thank you very much. The case will be submitted. We'll call the second case now. It's numbers 22 CV 636 and 22 CV 645. H27 versus Elevate and Elevate versus H27.
See. May it please the court, Brett Berman from Fox Rothschild on behalf of the appellant and cross appellee. While this is a somewhat straightforward commercial lease dispute, I want to frame the issues of why this becomes and should be very important to this court. And I'll go through the analysis later, but let me set the floor. If the court affirms with respect to, well, let me say this, if the court reverses to allow a commercial tenant to terminate a lease when the lease has no such termination right, it potentially changes the entire playing field for the landlord-tenant commercial relationship, not only in DC, quite frankly, but in all the 50 states, because there is not a single case that I could find anywhere where a court in DC or otherwise has ever taken a lease context in the commercial context like this and found that you can, despite the fact that there is no such termination right for a tenant to terminate, somehow create this extra contractual duty that allows it. So that's part one, where we will be shifting the playing field in commercial landlord-tenant relationships. And I would note, would actually create chaos when it comes to how landlords and tenants behave pursuant to leases all throughout Washington, DC and everywhere else. And secondarily, and I'll come back to the arguments, if this court does not reverse with respect to the mitigation analysis, just like I said before on the commercial landlord-tenant relationship being brought into flux, this court will create law that is different than law anywhere else, different than law in DC and different than the law in all 50 states. And the reason for that is because the standard for a landlord to mitigate is one of reasonableness. And it is an affirmative defense of the defendant, the tenant, to prove at trial that it was not reasonable, not flipping it on its head like the judge did here and finding that it's an absolute standard with absolute requirements and absolute deadlines where a landlord, if some judge or some jury believes you didn't do one thing, that all of a sudden you didn't mitigate properly. That is not the law on mitigation in DC. It is not the law anywhere. So while this is a straightforward, in the context, landlord-tenant case, I urge the court to take it very seriously, as I know you do every case, for the context that these two concepts would radically alter the playing field of commercial landlord-tenant relationships. So going to the actual merits of what we have here, we had a pretextual termination by a tenant who decided that they wanted to use COVID to their advantage to create things that didn't exist by lease.
I don't know what work the word pretextual does for you. If there was in fact a material breach of the lease and they had a right to terminate, whether or not they had another motivation doesn't matter, right?
You're right, except for they didn't, it wasn't whether or not it's a material breach, quote unquote, is irrelevant to whether or not they had a contractual right to terminate.
It's irrelevant to whether or not they had a contractual right to terminate?
The lease itself had three very key provisions that the judge went through in very clear detail. One was what would happen in the event of any breach by the landlord under the lease. And in the event of a breach by the landlord under the lease, they had a right, a contractually negotiated right by sophisticated parties with sophisticated counsel. And that was not termination. It was you can bring a claim against the landlord for whatever you're claiming the landlord did wrong. So
You're talking about the no rental offset provision.
It's more than a no rental offset provision as set forth by the court.
Talking about the provision that's labeled no rental offset.
Labeled that, but the terms are very clear, and the judge in the lower court went through exactly how that dealt with all possible claims that could be brought if you were talking about specific items in the lease. It is not you get to terminate where there's no termination right. It's you get to assert a claim in an independent action against the landlord.
Right. So let's come up with a hypothetical. There is no right to terminate underneath this lease if H27 also let another tenant into the space and let them work there with their 100 employees. Your view is that would not give Elevate a right to terminate the lease because the no rental offset provision says they have to proceed in court. Is that right?
I think the hypothetical you're posing is the landlord allows a new tenant to just kind of walk in.
Yeah, I'm talking about a clearly material breach of the contract that goes to the essence of the contract. They're no longer in sole possession of the territory. And what I'm positing is, it seems like a very surprising reading of the no rental offset provision that they couldn't walk away from the lease at that point.
Well, I mean, when you say walk away, they would assert an independent.
They would say that we're terminating the lease. You've breached it in a material way.
They don't have the right to terminate under that. But again,
I mean, I don't understand why. Where does it say there is no right to terminate? Where in the contract does it say, sort of the basic contract principle is if it goes to the essence of the agreement,
Yep.
sort of if it really undermines what the parties
Yes.
have agreed to do, well, then you have a right to terminate. You don't need a contract for that. That right just exists. Now, the judge said, well, this no rental offset provision waives that right to terminate perhaps in the sweeping manner that you think it does, that it's, cross-cutting no matter what they do. But where do you get that out of the no rental offset provision? What language tells me that if they really don't uphold their end of the bargain, they lock you out? They put new locks on the doors, or let other tenants in and deactivate your key cards. What about the no rental offset provision tells you that they can't terminate?
You still have the right to then sue the landlord for breach, right? It's the unilateral termination is where I think, quite frankly, Judge, you're taking a bridge too far, right? This was not, we went into court, filed a lawsuit, claimed in a deck action, we have a right to terminate because we had a breach, or in your scenario where all of a sudden the landlord comes in with commandos and commandeers the space and locks them out.
I didn't mention commandos.
Well, but the concept is that all of a sudden a sophisticated landlord is going to just change the locks and let people in. First off, that's illegal self-help. There would be a remedy in landlord tenant court for that. But so play that your hypothetical scenario out to its extreme. What a tenant would be able to do there would not send a letter from counsel saying I'm terminating. And
they have to keep paying rent under your view.
They would go to court.
But they'd have to keep paying rent in the meantime, otherwise they're in breach.
They would need to go to court. And in your scenario,
where do you see that in section 16.4 of the contract? Where does it say there's no right to terminate, even for clearly material breaches of this contract?
I will tell you,
please,
it's because the contract says what rights the tenant has to terminate.
It articulates a couple. You're saying that's an exclusive.
That is exclusive. And why?
It's not even underneath the right to terminate provision. It's under Article 18, damage or destruction. And it gives very specific time, it gives some very specific reasons why the tenant might be able to terminate when restoration takes longer than 12 months. I agree with you there. Yeah. Where does that purport to be the exclusive basis on which one could terminate?
You have two ways to get there on this record. One, we believe the contract is unambiguous, as the judge eventually found. And on that, he said, based on the reading of the contract and the provisions at issue, that there was no right to terminate. But we could go further than that on this record. The judge, because he initially found that there may be ambiguity with respect to the scope of all of these provisions, allowed extrinsic evidence in and heard testimony about the negotiation of all of these contractual provisions, including the negotiation of the language with respect to the security deposit, including with respect to the termination rights, including with respect to the section you're referring to. So not only did the judge, despite the fact that he didn't need to, he affirmed our position two ways, which is why it can't or should not be reversed, because then it's going well beyond the scope of what this court should be able to do on that record. Because I'm
sorry, I've lost you there. Because your argument is we'd be going beyond the scope of what we're able to do if we reverse the trial court's order. Because why?
One of two reasons. A, because the court found it's unambiguous. But even if you don't agree based on what you're saying that it is ambiguous, the court then heard parole evidence on all of these issues and weighed the credibility and evidence and emails and communications among counsel and parties about how all of these specific provisions came to be and how the termination clauses were shaped and what the rights are of the tenant and what the rights are with respect to the language of the section you're talking about.
What's the most compelling thing that comes out of that parole evidence that supports the point you're making?
Ron Bondi's testimony is set forth in our brief that they tried to get these changes made, tried to get further termination rights, tried to get ability to bring claims against the landlord in a different manner, and they were rejected, right? And that's, so when you look, that was my point, that when you actually look at the parole evidence that the court allowed in, although we don't think he had to because it was unambiguous, when you do look at the record evidence of what the court considered to reach that conclusion, he bolstered the decision by finding that sophisticated parties with counsel looked at these issues. They tried to get those provisions into the lease on certain points, and they were rejected by the landlord.
I think what Judge Beckwith is asking is, like, point us specifically. What's the evidence? Was there at some point suggested that they should have a right to terminate if the security deposit refund wasn't timely? Never.
No. And that's, so one of the point was there was what was before the court were various versions of these contracts.
I think it would be more helpful to your position if that had been suggested and had been rejected. But what if it just didn't come up?
Well, it's not that it just didn't came up. There was then negotiation on the other section you're talking about. right? And what the rights were, and we lay it off, it's in the record. So it's not that, yes, you're right in the sense, would it have been more helpful if the landlord had a negotiation where they said, no, you can't terminate on the security deposit, but let's also, to your point on the materiality of this, and can you breach it, why your hypothetical is radically different than the facts here is because this is a security deposit designed to protect the landlord, right? And that is also what the judge said, right? You're looking at not some vehicle that was a tenant protection mechanism. This is a landlord.
The
protection.
refund was a tenant protection mechanism. And why again wasn't that piece, the 38,000, I think, of the security deposit refunded as contemplated under the contract?
Sure. So if we look at the dates of when these things occurred, the notice, forget about the legal notice, we'll get there in a second. This was when the entire world was shut down, right? This was not later in COVID, a year later. This was April of 2020. This is a commercial landlord that has buildings around the country. Their offices were closed by government order, and it was chaos, right? So what the testimony was from Jacqueline Scanzello, the property manager, was it simply fell through the cracks. That was the testimony. We're not talking about in any normal period of time, as we all remember very well. This was the heart of the time of pandemic, right? And to your point before, when you said we shouldn't look at the motive, I understand your point on that, but we do need to somewhat look at the motive if we're going to go down the lines of the how, why, or is it material to the text exchanges between these individuals about this exact issue. And I don't know how much you've seen in the record where they said, quote, I hope the pandemic lasts longer. May, June, and July would be like 60K in savings. Yes, I agree. We are somehow ending up better in this pandemic, given the state of how many people are suffering, or let's figure out how to get out of the lease using this pandemic as an excuse. That's the time period we're talking about, and the tenant who concocted these claims by not having a landlord respond in the heart of a global pandemic to immediately return a security deposit because it slipped through the cracks. So I agree in the ordinary sense, we wouldn't have to look at that, but the court heard the evidence on that and heard exactly what this tenant was doing to try to manipulate a lease that didn't have such a right.
But we don't get to any of that if we don't think that there has been an express waiver of the common law right to unilaterally terminate for a material breach in the contract, correct?
Well, whether there's an express waiver, I think you have to then look to the, there's not a single case in DC that's been cited in the landlord tenant context where you would allow a termination right that doesn't exist by contract on any ground like this, right? There's nothing been cited by the adversary. If you look at the cases that have been cited for this, they're not even remotely alike, but they're non-landlord tenant cases.
But you agree there is a common law right to terminate for a material breach. Can we agree there?
Do I agree there's a common law right? Are you talking about in a general contract sense, or are you talking about in a negotiated lease provision sense with commercial?
I'm saying it's a background principle. There is a common law right to terminate in the event of material breach. One could contract around that. And the question here is whether they did.
Right. So the answer to your question is, I think there is a general law, there's a general premise that I agree with, but in the landlord tenant context, where parties negotiate every single day about termination rights. And here there were specific enumerated rights for termination and specific negotiated provisions on what happens in the event of a landlord breach. They contracted around it.
And so then what do you do with section 20.5, which talks about common law remedies or just sort of reserves other remedies?
Exactly what the judge said, that those remedies are not reserved on these issues that we're talking about because these parties made very specific negotiated provisions on what their remedy would be pursuant to the contract.
And that is 16.4. So if we think that we need to read 16.4 and 20.5 in harmony, do you agree that there's a world in which there could still be a common law right to terminate?
There would be no world in which there would be a common law right to terminate this lease on these bases because of all of the lease provisions. And as I said before, the judge went further than that here, right? The judge didn't just rest on what you just said, Your Honor. He actually heard the parole evidence about how the pudding was made on these leases, what the negotiations were, and found that in light of that parole evidence, that this does not make sense.
And that was great for him, but we're reviewing this de novo. And so we don't even get to the parole evidence if we don't think we need to based on the contract.
Correct. But my point in saying that again is that you have two different ways to get there. And the problem with the reading or a decision with respect to that to allow a tenant to reserve a common law duty that's directly contrary to the negotiated contract rights would be the first of its kind, right? Because there are no cases that have ever allowed it in this manner. Not a single case has been cited anywhere in this type of context where that would occur at all, right? So we would be creating law that doesn't exist based on those set of hypothetical facts, because this is not what happens in the commercial landlord-tenant context where parties specifically negotiate these contractual rights. I know I'm over time, but I haven't even got to the damage piece. Can I?
Go ahead and, yeah.
Okay, I'm sorry, but
Make it
so
quick and.
if we then go to what I said was another fundamental and perhaps even more fundamental in many ways from a landlord perspective, is this concept of mitigation. And the law here has been essentially turned on its head by saying that let's talk what this landlord did briefly, right? In the heart of the global pandemic we're talking about, they immediately went and hired Newmark, the largest broker in the country, to come in and list this space. They then got 3D comprehensive plans done of this space, which is well beyond the scope of what landlords were doing then, now, or ever, because they knew that the marketplace had shifted and therefore people would be viewing it online. So they wanted to have this expensive, radical plans drawn up that people could tour the space without having to violate government orders. They created comprehensive marketing materials. They listed it on CoStar. They sent it out to the entire brokerage community. All of these things were being done within months, right away after the tenant vacated unilaterally without a court order, right? They didn't go to court and get a court order. They just walked out in the middle of the night the same day that they served that letter we're terminating. And that series of things was happening again during the government shutdown orders, during the worst part of the pandemic. Then what the court did was say, without any evidence, and let's talk about the burden real quick, because it's also a very important fact here. The burden to prove that mitigation was not done reasonably is on the tenant. It's on an affirmative defense basis.
Yeah, but I mean, they don't need to prove it beyond a reasonable doubt.
You're right.
And what we have here are emails from early January that say, you know, we've got a tenant who's interested. We want to see square footage and 2D floor plans. And in that same exchange by January 19th, the response is, yes, we'll have them soon. There's never an explanation offered by H27 in the testimony. What was the holdup and why the sort of evasiveness on like, where are these things? I mean, I don't think you need to be an expert to know. You can get measurements and floor plans. It might not be industry standard. It might not be necessary when nobody's asking for them, which is some of the testimony you're highlighting for us. But when you've got a tenant who says, we'd like to move in by the end of the year, can we get these things? That would be too difficult. We can't do that in a short period of time. The contemporaneous email exchanges are, yeah, we'll get that soon. And then it's just dropped ball for many months. And that's really hard for me to see how that can't be evidence that supports the trial court's finding on mitigation.
Well, here's what I would say in response to that. None of that is record evidence in the sense that any of it was subject to cross-examination or put forth by the tenant in any meaningful way. The only way
I don't know, those are very different things. Is it evidence in the record before the trial court?
Well, this is exactly the situation.
It's a yes or no question. Do you think it's evidence that was in the record before the trial court?
I believe it was hearsay.
You raised hearsay, non-authenticated objections to the evidence that was before the trial court?
This didn't come up, but let me tell you why, right? And this goes to the heart of the issue here, right? This is the problem with the entire thing. First off, the emails don't say that. They don't say we have a tenant ready to move in on that day. It's not that at all. It doesn't say what floor plans were provided. It doesn't do any of those things because what we have here, the only way this came into evidence is on cross-examination of our witness, where these emails, one set of emails, were put before our witness, and he said it was not unreasonable to not have these set of plans. So it brings us into the only analogous case, which is the Kirby, the Norris versus Green decision, where the only way this type of evidence comes in is through the cross-examination of a witness, which the court found is not proper, doesn't set a reasonableness standard, and doesn't achieve the objective. So that's the problem with it. It's not whether or not it was in evidence. It was how it came into evidence at all was actually refuting the fact that this was not reasonable or that it didn't exist. So there's no testimony by any of the parties on these emails. There's no testimony by anyone on behalf of the tenant. The only testimony you have in the record is contrary to the argument, which was Mike Goldman, the expert, was asked about these emails and said, it's perfectly reasonable not to have that because of the following reasons.
Did he say, and if you're asked by a prospective tenant to get those things, it would be perfectly reasonable to fail to do that for 5 months?
No, because again, that you just illustrated my point that this is not in evidence. The tenant never brought this into evidence to prove anything. They asked a single question or two about the email, and the expert, the only testimony in this entire case about this was that it was not unreasonable, right? So we're then
Okay, but no, when you say it was not unreasonable, I think what you're referring to and what your expert testified to were the marketing efforts up until January, February, March. I don't think there is testimony that then failing to accommodate what seemed to be a very serious prospective tenant who had said explicitly they thought this would work out. This is the space that they want to be in by the end of the year, and failing to provide any explanation for how you can fail to get them something somewhat simple. I mean, I don't know why you need an expert to testify to that. Why can't a trial court use its head?
because it didn't come into evidence any other way. So this is my point. This is an affirmative defense by the tenant who would have to prove the lack of reasonableness. And just to respond to your
You can't prove a lack of reasonableness through another party's witness?
Not on cross-examination in the way it is. And then I defer you back to the case I just said to you, Norris, which is exactly what they tried to do with the landlord representative to cross-examine, and the court found that doesn't set a standard. And that case is on all fours with respect to what's going on here. But just going back to Judge Deal, what you said, what Goldman testified to was that it was not unreasonable that the two-dimensional floor plans were not available as of March 3rd, 2021, when the two-dimensional plans were not necessary but complicated. He went on to then go through the fact that even though the two-dimensional plans were not yet available as March 3rd, 2021, brokers who were interested in the premises were able to take a three-dimensional floor space, which Goldman testified would be preferable simply to viewing a two-dimensional floor space. So that's what I'm saying, that the only record evidence about this, the only record evidence is cross-examination of a witness, which has a major problem under the Norris decision. And even if you then look to what the testimony was, it directly refutes the judge's finding as to whether or not it was reasonable, because the testimony was that it was not unreasonable by the only person questioned about this. And there was no testimony, no cross-examination of any other witnesses. There was no testimony brought by the tenants on this. There was no affirmative testimony brought by their expert on this. And even most importantly, there was no testimony of the people who were writing these emails to give the context that, Judge Deal, you're jumping to the conclusion that there was a ready, willing, able tenant to move in. But when we then go beyond the failings of Norris, because it was only through cross-examination on directly contrary evidence, we then look at what the judge did, which made it even worse. The judge then found, if you're right, that the simple not getting that plan by that date was thwarting or not unreasonable, that despite the experts who all said it would take all of these months to get tenants in the space, and then more importantly, there would be a period of 1 to 2 years of free rent for those tenants to get in the space, he disregarded that. And he found that all of a sudden the rent would start immediately when the tenant moves in the space, right? And the problem with that is it's refuted by both experts. It's refuted by the facts in this case where Elevate was given free rent and then 2 years of half rent. and all of a sudden jumps to the conclusion when there is no tenant, when there is no proposal from anybody, that email leads to a willing, able tenant that all of a sudden walks into the space that day and occupies. That's directly contrary to the record evidence, right? So when I started the argument that this radically reshapes mitigation, it reshapes it because it creates some sort of absolute standard, not a reasonableness standard for landlords to undertake. And by the way, this is all in the middle of the global pandemic. I have to add that on top of it to show what they did. So it creates this strict scrutiny like standard for a landlord where no case in DC or anywhere else has it. But more importantly, it then, if we're going to not stop there and we're going to look to actually what happened and what the evidence was on what it would have been that the damages would flow there from, if we were going to accept that as true, then it just completely disregarded every bit of evidence in the case from everybody about actually when you would get a tenant paying rent. And to the point before, I think it was from Judge Ali Khan about on your question with respect to the issues of, do we have this common law right out there of, terminating a contract despite the fact here that the contract doesn't say it? Let's look to both the lease and the common law when it comes to what you're supposed to get when you find a breach of contract, right? Which has not been waived away here. Here, the lease itself talked about exactly what this landlord would get in the event of a tenant leaving the space early and not paying rent. That was disregarded. But even further than that, when you look to the general contractual duties you were referring to before, the point of when you win on a breach of contract claim is to make the party whole as if the contract was performed. What we have here is some sort of Frankenstein's monster. We find a clear breach. We have record evidence that shows that it would have been much longer to get paid rent, yet we disregard all of it, and we disregard the common law if we want to look there, and put my client in a worse position than they would have been because they didn't have a tenant even then, and they wouldn't have had a paying tenant in this hypothetical landscape much later, right? So that's why when you look at the record evidence, it doesn't support this position on the underlying point. And when you go further and look at the actual record evidence on the damages, it just completely throws it out the window. And then the final point I'll make, because I know I'm way over time before reserving, is on the attorney's fees, because just like this issue, if the judge was wrong when it comes to all of these vast reductions or the mitigation, then the attorney's fee issue also needs to be reversed because it was only reduced based on some finding that we didn't get 100% success. And what I would say to that even, I think that's wrong too, because the entire fundamental premise was, did they have a right to terminate? And the court found they did not have a right to terminate, which means there was full success, irrespective of reducing the damages. And there's plenty of case law on that. So with that, unless you have any questions, I'll reserve, and my apologies for going over.
Thank you, Mr. Berman. We'll give you a couple of minutes on rebuttal.
Thank you, Your Honor. May it please the court, I'm Matthew McLean. I represent the appellee and cross-appellant Elevate LLC. And what I'd like to do is address the liability issues, which is our cross-appeal first, and subject to your questions, then move on to the damages issues.
Great.
With respect to liability, the standard before this court is de novo review, because this is a contract interpretation issue. It is our contention that the lease is unambiguous. And that this court should enforce the lease that these sophisticated parties made, and not the lease that the landlord wished it made. It is undisputed in this case that H27, the landlord, breached the lease by failing to return Elevate security deposit reduction within the 30 days that were required by the lease. As the trial court found, that reduction of the security deposit was, and I'm quoting here, heavily negotiated by both parties. By keeping the security deposit reduction that it wasn't entitled to keep, H27 took for itself a benefit that it was unable to obtain through contentious negotiations.
Now, before your client walked out of the space, the offer was on the table to return the security deposit. So I don't think we're talking about whether or not the return of the security deposit was a material term of the contract. I think what we're talking about is whether or not a 3-month delay in that security deposit's return. Am I getting that about 3 months, maybe 2 to 3 months? Whether that was material, and once it's been offered back to your client, they walk out anyway. So that's Seems like a pretty surprising conclusion to me. This is an 11-year contract. We're talking about 1 month's worth of rents refund offered back to your client within a couple months of when it should be returned. Not perfect. But does it go to the essence of the agreement? Does it go to the heart of the agreement between the parties so that we could say that it triggers a right to terminate? Seems like a pretty surprising conclusion to me.
Well, it goes to the essence because that's what the contract says. The contract says time is of the essence.
So you think that provision, so if there was a provision in this contract that said H2 is required to clean the floors once a year using a professional grade industrial floor cleaner every 12 months, and they instead take 13 or 14 months to do it because it says time is of the essence in the contract, that's a material breach that gives you a right to terminate?
Well, I mean, you're proposing a different contract because that's not an obligation that was in this contract.
Correct.
But certainly if you had a contract for floor cleaning, for example, and the contract says the floors will be cleaned by this date, and the contract says time is of the essence.
In two totally separate provisions, right? Like here. There is no time is of the essence provision attached to the refund of the security deposit. It's a pretty generic, if I remember right, it's a generic clause in the contract. So you think in that case, you get to breach an 11-year lease because the floor cleaning got screwed up?
Well, I would say it's not a breach for us to terminate the 11-year lease.
Right. No, so yeah, you would have a right to terminate by
yeah.
their failure to complete the floor cleaning in time.
So, Your Honor, I don't know if the provision is generic or not. It's the provision that the parties agreed to, and it says except as expressly otherwise herein provided, time is of the essence in this lease. And that provision actually appears in two different places in the lease. One of those places makes it clear, based on its position, that this is a provision that's applying to both parties. This is a provision that the landlord proposed. That's what the parole evidence shows. We agreed to it, but it applies to both parties. The other place it appears is in the definition of time, in the definition of the word days in the lease. So whatever provisions that this time is of the essence clause applies to, it has to apply to those provisions that express obligations in terms of numbers of days, which the security deposit reduction does. And I would also, just to go back to your earlier point, Your Honor, I mean, this is not just a case where the landlord failed to make a payment on time and then offered to make it a couple of months later. That's not what happened at all. They failed to make the payment on time. First they acknowledged receipt of our request for the payment, triggering the 30 days.
That was April 23rd, right? That's when they got the notice that you wanted your refund?
That is correct, Your Honor.
May 23rd to refund it, okay?
That's correct. Elevate didn't just terminate as soon as they missed that deadline. Elevate waited until June 23rd of 2020 to send a notice of default and demand to cure. Now, there's no requirement in the lease for Elevate to have done that. They were permitted under the lease to provide a notice of default and demand to cure, and so they did. They provided another 30 days to the landlord to pay the security deposit reduction. They got no response. Now, we heard, well, it fell through the cracks, using COVID as an excuse here. Okay, that's not what happened at all. We have in the evidence the privilege log of the landlord, where they are talking among all the top executives, the senior vice president and their general counsel, about this request for security deposit reduction and the notice of default and demand to cure. Multiple emails going back and forth, some of which towards the end, before we send them notice to terminate, are talking about the possibility of the termination of this lease. That's what's in the evidence, Exhibit 101. They knew that this was a possibility. They knew that they were not going to respond either to the original request or to our notice of default and demand to cure, which I think we were generous in giving them. And then it was only after they failed to do that we sent a notice of termination. And it was only after we sent that notice of termination that they came back and said, if you will waive your notice of termination, then we'll give you your security deposit reduction back, which we were entitled to all along. And the judge found we were entitled to. They had no right to withhold it at that point. So you said there was an offer to pay it. It was. I think it was more accurately characterized as a threat not to pay it, because we were entitled to it already. We didn't need them to offer to pay it.
And your point is that the parole evidence indicates that the landlord knew that you were entitled to terminate. And if that's, part of the evidence, why did the judge see it differently? And what kind of standard of review do we apply to that?
I'm sorry, and I apologize if I wasn't clear, Your Honor. I'm not talking about parole evidence. I'm talking now about after we sent the request for reduction, and then later sent. So this wasn't during the negotiation of the contract. This was when we were giving them notice, and then during that period of time, when the landlord should have been saying, "Oh my gosh, how did we miss this? Here's your check." They were instead communicating back and forth among the high level officials, including their senior vice president and their general counsel, and talking, among other things, this is in their privilege log description, about the potential for termination of the lease. So they saw this coming.
So why are there these separate right to terminate clauses in the lease? If time is of the essence is enough, you don't need this separate. If damages aren't fixed within a year, you have a right to terminate. Why? So there are specific rights to terminate contemplated in this contract that the tenant has. They seem to speak to far more severe deficiencies than what we're talking about in the refund of the security deposit. It is basically, this is uninhabitable for a year or more. What's the point of those provisions?
Well,
why shouldn't we read those as exclusive rights to terminate in the tenant?
First of all, Your Honor, I wouldn't agree that those are more severe situations, at least not in terms of a violation. In fact, these two express rights to terminate, one is in the event of certain casualty conditions, and the other is a one-time right to terminate after 7 years. So neither of these things necessarily would involve a material breach by the landlord. Okay, these are rights that are given to elevate under certain circumstances to terminate, even in the absence of a breach by the landlord. The reason why so they had to be at the lease expressly, because otherwise these rights would not have existed at all. Now you might be able to get to at least the casualty one through a different mechanism, but this was the mechanism that the parties chose, one that would under certain circumstances allow a termination even in the absence of a breach. There was no need, on the other hand, to specify you can terminate in the event of a material breach, because that is embodied in the common law, and the parties did agree specifically to section 20.5 of the lease. No right or remedy herein conferred. So that would include the right to terminate under certain circumstances. No right or remedy herein conferred upon or reserved to landlord or tenant is intended to be exclusive of any other right or remedy, and each and every right and remedy shall be cumulative and in addition to any other right or remedy given hereunder or now or hereafter existing by agreement, applicable law, or in equity. And by the way, while we're talking about parole evidence, the parole evidence was that the landlord proposed this provision but said no right or remedy herein conferred upon or reserved to landlord is intended to be exclusive. We negotiated in the landlord or tenant so that this provision would apply to both parties equally.
What is your response to your opponent's description of what was going on as you trying to get in the provisions that would allow you to have this right to terminate in the case of a material breach?
I do not have any idea what he's talking about.
That's a response.
No idea whatsoever.
Okay.
That was not in the parole evidence.
Okay.
That was offered at trial. It's the first time I've heard that.
So what work do you think 16.4 is doing, if not to prevent a situation like this?
So, Your Honor, 16.4, which I would say is the determinative issue of this case on the liability side, because the judge's finding was that we waived our right to terminate. And we say 16.4 does exactly what it says, which prevents us from withholding rent, and that's all. The provision says no rental offset, except to the extent expressly provided in this lease, in the event that at any time during the lease term, tenant shall have a claim against landlord. Tenant shall not have the right to deduct the amount allegedly owed to tenant from any rent or other sums payable to landlord hereunder. It being understood that tenant's sole method for recovering upon such claim shall be to institute an independent action against landlord. So method.
So there we have, I understand the security deposit amount to be refunded was about 1 month's rent. So I think 16.4 could be read as saying, well, you can't just not pay your rent for that month. You have to bring a case in court, which you did not do.
Well, we did do that. The question that's presented by this, we brought a case in the form of a counterclaim after terminating. The question that's presented by this provision is whether termination is a quote method for recovering upon such claim, because that's all we've waived as a method for recovering on such claim.
So you would say on August 1st, you could not withhold the rent as like an alternative means of recovering the refundable part of the security deposit, because then you would be in material breach of the lease. So you didn't have sort of a self-help way of getting that money back yourself. But that lack of self-help doesn't prevent you from terminating in response to a material breach. Do I have that position correctly?
That is exactly right, Your Honor. We could not remain in possession of the premises and not pay rent. And we paid rent right up until the moment we moved out. But this provision does not keep us from terminating the lease. It keeps us from using it requires us to bring an action to recover the amount of our claim. Our claim is for $38,316.75. That was the amount of the claim. We did not recover a penny of that prior to termination. We had to bring an independent action in the form of a counterclaim to try to recover that. And we won a judgment on that claim, which we still haven't recovered. So
what if I agree with you that 16.4 doesn't speak to the situation, that the no rental offset provision doesn't alter sort of your common law rights to terminate where they might otherwise exist? Does that raise, usually materiality is a question for the finder of fact. Seems like a stretch to me to say this delay in refund of this. I mean, I understand you say time is of the essence makes it material. I tend to doubt that. Would that be something to remand for the trial court to consider? Or do you think as a matter of law, we could decide it, whether or not that's material, whether or not that, I think sometimes the language when it gives one party a right to terminate a contract is quite severe. It's things like, does it go to the heart of the agreement between the parties? And I have to say, a 1 month, 2 month delay in refunding 1 month's worth of a security deposit does not strike me as going to the heart of a 132-month lease. So is that a finder of fact question, or is that something we should settle as a matter of law?
it's not a finder of fact question, Your Honor.
Okay.
And that's because it does go to the essence of the lease, because the parties agreed that it goes to the essence of the lease. And that's what time is of the essence does.
So can I just get your answer? So it's for us to decide either way, or it's for us to say if you win, but if you lose, you want to remand. What if we just disagree with you on that? Is that something that we should decide? Either way. I mean, I hear you saying, well, if I win, I want to win now. What if you lose? Do you want to lose now, or would you want to remand?
So I think the hypothetical you're asking me is, Your Honor, if you were to conclude that the judge was wrong, that we waived our right to terminate, but if
it comes to us on the question of whether or not this is a material breach that gives rise to a right to terminate, is that something we should be deciding in the first instance, or is that a question for the trier of fact?
If we were to set aside the time is of the essence provision and ignore that, then my answer would be the trial court, because of its finding of waiver, did not reach the question of materiality, and it should be remanded for that purpose. But because that would be in the absence of a time of the essence provision or another provision specifying what the parties regard as material, that would be a question for the finder of fact. So that's my answer to your question. But as I've said, under what we think is clear case law in both DC and also Maryland, the DC case law is based on Maryland case law on this issue. The parties to an agreement, I'm quoting here, may make time an essential part of the contract. And in such cases, the failure by one of the parties to perform his part of the obligation within the time prescribed discharges the other from all liability under the contract. That was in Siegel versus Banker. It was reaffirmed as recently as 2019 in SJ Enterprises LLC versus Quander. A quote, time is of the essence clause makes strict timeliness a requirement. What the time is of the essence clause does is it reduces the materiality question down to a single question. Was performance timely? That's the end. And I do detect maybe some concern or squeamishness about what some might consider a harsh result. But the whole materiality, the existence of the materiality principle that a breach must be material before justifying a termination, that in and of itself is a judge-made rule. It's a judge-made rule that the parties can opt out of, that sophisticated parties in an arm's length transaction can opt out of. And as a matter of fact, the time is of the essence rule actually goes back even further than the development of the material breach rule. This is an ancient time-honored principle that if the parties wish to agree to a time is of the essence provision, they can do so and they can live with the consequences. And it's rational. Rational business people can and do decide life is too short to be in business with people who aren't going to meet their obligations in the time required. And if that happens, I'd rather go and do business with somebody else. Not everybody will choose that, but it's a rational choice for those who wish to make it. And time is of the essence is a simple, clear, unambiguous, and long applied provision by which the parties will decide to do that. So I don't agree with H27's position that this is going to upend lease negotiations throughout the district and the world. That would presuppose that parties everywhere are agreeing to these time is of the essence provisions. I'm not aware that that's the case, but if it is the case, that in itself should be a clear signal that this is something that the business community does want, that they are willing to be held to strict timeliness requirements in exchange for the ability to enforce their contracts, and they are willing to walk away from contracts when they're in business with people who won't do that, who choose not to do that.
Can I skip you ahead to the damages calculation? I have a question about the trial court's whether or not its damages calculation was supported by the evidence. I'm particularly concerned with, I believe there were two competing experts. There's Mr. Goldman, Mr. Kluger. Mr. Goldman seemed to think, you know, if we assume that mitigation efforts were no longer reasonable as of March 3rd, 2021, he says, well, you're going to be waiting a while before you get a tenant in that space. I think 6 to 12 months was roughly the estimate. And then you're also going to have a rent abatement period as an incentive. And that's going to take you something like 18 months out before you're really seeing rent. Mr. Kluger, your expert, accounted for an 8-month rent abatement period, which would take you to roughly November, but didn't say anything, so far as I can tell, about how long before that lease would begin to run, how long before that tenant is in the space. And the only viable tenant wants to be in at the end of the year. Let's call it November. So shouldn't the rent abatement have run from when a judge could have found the tenant actually would have been in the space? Does that make sense? It seems to me that the judge was treating that March 3rd no longer reasonable mitigation. Now you've got a tenant in there, and that's when the 8 months start on rent abatement, when I don't see what evidence would support that type of calculation.
Your Honor, I do believe that the judge did take into account the 8 months that it would take to get into the space. So I don't think it was an assumption that right away the tenant would be in the space. I would
But
also.
I think Judge Deal's question is the 8 months goes to the abatement piece, not to the how long to find a tenant piece. And so it seems like there should have been, you know, an assessment of whatever it would have been reasonable to find a tenant, and then the 8 months would be tacked onto that.
Oh, I understand. Thank you, Your Honor. About all I can say to this is that there was expert testimony on both sides, that the judge chose to credit certain parts of each expert's testimony and chose to just not to credit certain parts of each expert's testimony. Put together a very, very detailed, I would say unusually detailed calculation of how he came based on all of these different metrics to the conclusion that he did as to the amount of damages to award. So, Your Honor, I don't know the specific answer to your question of how that calculation takes into account rent abatement or not. What I do know is that each and every step of that calculation along the way either credited or did not credit one or the other's expert testimony.
Yeah, see, here's my suggestion to you, and if you want to file a letter afterward to tell me why I'm wrong, I think I'll invite you to do that. But my suggestion to you is there are two different things that the experts are talking about. There's what I think Goldman refers to as a free rent period, which sounds a lot like an abatement period, which is just sort of we have a tenant, they're in the space. We're not going to charge you. This is an incentive that commercial tenants get. What's that number? And Kluger puts it at 8 months and Goldman puts it at something like 6 to 12 months. There's a separate question. How long before the tenant takes over that space? To which Goldman, I think, says also something like 6 to 12 months. I can't remember exactly. And Kluger says nothing. And my suggestion to you is what the trial court did is just sort of ignored that extra piece of it. How long before the tenant takes over the space and starts the free rent period on March 3rd. That's when the tenant would have been in there without a factual basis to make that finding. So that really there would have needed to be some evidence on when the tenant would have taken over, and whenever that date roughly is, that's when the free rent / abatement period should begin to run, so that your client might have gotten a significant discount under the trial court's calculation of damages. If you think there is evidence that Kluger all along was talking about, you'd be seeing rent as of November 1st, 2021. I'd invite you to point me to it now or later, but I just didn't see it.
And I am going to have to address that at, that level of the calculation. I'm just going to have to address later if you'll permit me to do that. I will say this though, the finding of failure to mitigate doesn't necessarily have to conclude that it would have been this particular tenant. It could have been any tenant. The point was that by March 3rd, the landlord had failed or was failing to do what reasonably should have been done to market the property. That was the finding. And the judge concluded that if proper mitigation efforts had been taken, then as a matter of fact, and again, not with mathematical precision or certainty, but as a matter of fact, they would have found a tenant within a time period, and then rent would have been calculated the way that the judge calculated. So we don't have a burden to point to, oh, this is the tenant that you would have gotten in and they would have moved into this on this date. We have the burden to show, specifically, we have the burden to show that the landlord failed in its, quote, duty to take advantage of any reasonable opportunity under the circumstances to reduce or lessen or minimize the loss of the damages. That was our burden. We met that burden. Now, in terms of how you go from there to calculate damages, and the how the specifically a rent abatement period would or would not affect that calculation, I will have to submit by letter. So I appreciate your opportunity, you giving me the opportunity to do that. And I see that I'm out of time, so I will take the opportunity just to say we ask that the court to reverse and render judgment in favor of the tenant Elevate. And I think both parties agree that if the court were to reverse the trial court's decision it should be remanded for a reassessment of attorney's fees. Thank you.
Thank you, Mr. McLean. Mr. Berman, we'll give you 3 minutes.
Thank you so much.
And Mr. Berman, I'd like to start you with a question.
Yeah.
And that is, you spent a lot of your time today saying that it's just sort of anathema in the commercial lease context to have a unilateral right to terminate. But I'm looking back at trial exhibit 40, which is Joint Appendix 496, and it's the letter where you offered to pay the outstanding security deposit that had not been returned. And you say, you think that 16.4 controls, but you also do acknowledge in that letter that if there is a violation of a substantial obligation of the lease, there is the ability to terminate the commercial lease early. And you cite a DC case for that. So, your argument there essentially is that the failure to timely return the security deposit is not material, but you seem to be acknowledging that we are in a world in which there is a duty either under common law or even within the course of this lease for there to be a termination for material breach.
I think my answer to you before stands on this, that I think I said yes, with the proviso that the parties here negotiated what the termination rights were. And that's when you look at the decision that I've repeatedly cited to, they say you can't just ignore what happened here with these parties in this sophisticated transaction. Whereas Judge Deal was talking about very specific, serious types of breaches that would allow for a termination right. And that's why you can't just then turn to the general common law to abrogate the meaning of the agreement between the parties. So I don't disagree, and I stand by what I said before, and I don't think that changes it respectfully. Judge Deal somewhat took my thunder because there was a point I forgot to raise, and I'm happy you raised it on your first question, which was your question about the cleaning service. I was going to take it even further, but I got distracted in my argument, which was there are many things in this contract that would allow, under their theory with this time of the essence, if a day is missed, they say you didn't get our trash out on Sunday and they serve a notice on Monday and you don't get it done on Monday, all of a sudden they could terminate the lease. Literally every single thing a landlord does under this lease or doesn't do within a day.
I'm actually curious, could you point me to what one of those things would be? Because when I looked at the contract,
Yep.
that's 57 pages, I think, so I didn't
Yep.
read it all in detail. But my rough sense was, your obligations were to provide them the space. There's some build out obligations, I think, as well.
Yeah.
But I don't think you really had any continuing obligations under the contract.
Well, no,
In terms of maintenance, maybe utilities, although it's made explicit that they cannot terminate for a failure to upkeep the utilities or something like that. I'm just curious, is there actually an example in this lease of something that a failure to do on day X would be a breach under their theory?
100%. If
Sure.
you look at Article 14, Section 15.1, it goes through many things. You were looking at just the security provision, but maintenance and repair of all common areas, janitor service for all common areas, passenger elevator service, exterior window cleaning. I mean, there are many different things that the landlord, because it's their building, this isn't the only other tenant, has to do and has to maintain under parameters and guidelines within the building per building operations. And literally, if you take their example here, they claim that, and I want to get to another point, I know I have limited time, anything the landlord doesn't do immediately, they can walk out of the lease with a notice. That is just not what the law is. That is not what the lease says, and that would be a radical reshaping. With respect to the issue of
What is the time is of the essence provision? What does it get you? Like, what does it mean?
in a standalone context, it doesn't allow you to terminate where you don't have a termination right.
Sorry, I thought we had to read all of the services in 15.1 in accordance with 15.2, which says it creates no sort of obligations that would allow the tenant to get out of the lease. So it doesn't seem like we have that in the security deposit context.
I can't read it all very quickly. I know there are other obligations of the landlord in every lease. I just can't do it as quickly as I was answering the question. I'm happy to submit on that too, but I know there are obligations of landlord on the building to do certain things, right?
That don't have a failure to do so does not result in a constructive termination.
Well, I don't think there is any right under any scenario that you could have a constructive termination based on this period. So I don't, I don't think that section reads any different than any other section. Just to your point, Judge Beckwith, about what I was talking about and he said, I don't know what Mr. Berman's talking about. What I was referring to, just so we're very clear on the record, was if you look at page 7 of our breach, where I say they tried to negotiate the tenant tried to negotiate out section 16.4 entirely. So that's what I was referring to. We cite to it at page 7 of the brief, exactly what I was referring to. Tenant tried to get rid of 16.4. Landlord said, no way. That's staying in the brief. And that's staying in the lease. So that's what I was referring to, just to clarify. And then just back real quickly, because I know I'm out of time, to Judge Deal's point. This is not a new issue you're raising, right? Obviously, it's in our papers. They've never addressed this before, exactly how the judge did. He skipped a huge period of time, right? So we raised this both in our motion to amend the judgment. We raised this again on our appeal papers. So this is not like and I'm sure that's where you got it from, right? This was something that we have raised that Kluger didn't address it in any meaningful way. But we did, right? It wasn't refuted by Goldman that this is the amount of time it's going to take to get a tenant in post the actual time period. And as I said on my argument on the opening, we actually know from the record evidence itself, that's exactly what Elevate did, right? So we don't have to look beyond this lease, even pre-COVID, where they had a period of 2 years half free rent and a period of free rent, right? So it's not that we need to draw straws to say that's reasonable or unreasonable. The unrefuted record evidence is the Goldman testimony about how long it would take per what your question was. So I'm saying it because this is not new. This isn't novel. They've never had an answer to it because the judge, quite frankly, just missed it. And he set that date in stone of March 31 or March 8th and ignored the fact that it would take a significant period of time without rent. And that was just my final point, what I was saying before to Judge Ali Khan about this contractual right. So even if you assume there wasn't a problem with respect to the mitigation point and creating a new area on that, then you go back to the contractual analysis, which is he didn't even make us whole under the terms of the lease based on the record evidence, right? So that was the point I wanted to make. Thank you so much for your time.
Thank you very much. Thank you both for your briefing and your arguments. The case will be submitted and we are adjourned.
All rise. This honorable court is now adjourned.